Let's see here. All right. Hello and welcome. Oops, my angle there is kind of messed up on TikTok. Let me get that going. TikTok people are going to see my hand in the screen there for a little bit. Anyway, hello folks. Welcome. Some technological challenges here as we're getting going. Welcome. Thank you all so much for being here. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. Welcome to another episode of the Empowered Immigrant Live. Thank you so much for being here. Today we're going to be talking about key changes in Trump's first week, and specifically we're going to be talking about the Laken Riley Act. You know, what do we know? What this is? What do we need to be mindful of? That's what's happening, okay? And so thank you very much for being here. Remember, the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives, all right? So if you're tuning in right now, whether you're on YouTube, Facebook, LinkedIn, Instagram, TikTok, welcome. Thank you all so much. And so welcome. You know, thank you for being a part of this. Today we're talking about key changes that happened last week in Trump's first week, and we're going deeper into the Laken Riley Act, which is a nasty piece of law. And the news is that that law might very well be signed this week. We expect it to be signed by now President Trump this week, which is bad news, right? A lot of bad news, actually. So, you know, I ask everybody, right? Do you want to change something about your immigration situation right now? Do you want to find a strategy, find a solution, find an option, find a way to change or improve your life through your immigration status? Because if so, go for it. And I'd love to help you with that. My firm is on a mission to win 10,000 immigration cases in the next 10 years by 2035, all right? And we would love for your case to be one of them. And so thank you, everyone, for being here. And so now I'm going to jump right in, right? It's the end of January 2025. Trump is back and came back into office with a vengeance last week. My goodness, it was a crazy week. And now the Laken Riley Act is very close to being signed in. We expect it to be signed in this week. We'll talk about that today. All right. And ICE, in the meantime, is talking about mass deportation efforts. Raids have started in some places. We're going to see more of that, folks. All right. We're going to see more of it. And so some of the key changes that happened last week, right? There were 46 different executive orders signed on Trump's first day. 7 of them were immigration related, right? Crackdown at the border, declaring a national emergency at the border, getting the military, right, involved with basically ensuring that the border is closed to any and all unlawful entries. They ended the CBP-1 app. All right, they ended the Cuba, Haiti, Nicaragua, and Venezuela parole program. CHNV parole program, that's what they're talking about. Cuba, Haiti, Nicaragua, and Venezuela. All right. They ended catch and release, meaning they're going to just detain a lot more people. All right. They ended the refugee admissions program. They are looking to increase, to the full extent possible, expedited removal. Okay, which is really bad for due process. There's a memo that was released. Now there's a lawsuit that's been filed against it. We can talk about the backlash. We can talk about the response. We can talk about the lawyering that's happening right now. Fighting legal fights in courts, right? We can talk about that. All right. One thing that I didn't announce last week because, but for various reasons, but Trump fired some top immigration judges, among other things, right? There's lots of different things happening, but that's also just a nasty indication of is this an impartial judiciary? Are the judges really free to like actually make their own decisions, or do they have to make the decisions that the president wants them to make? Deport a certain number of people or you'll get fired. Yeah, that's a pretty nasty situation. All right. All of that is happening. All of that is happening. And here we are. Okay? Here we are. And thank you for taking your time to be out of your busyness and out of your schedule to be here with me right now. And it's like, let's get on the same page and let's think this through and let's strategize and let's find a way to improve our lives even despite all the craziness, to improve our lives through immigration law, even despite all the challenges with immigration law. All right? And let's at least get informed. And often, the solution often starts with getting informed. And so, the Laken Riley Act is our theme for today. And I want to talk about what this is. All right, what it is and what it is not. Okay? And so it's gone through the House and the Senate and then back to the House. And this week, we expect it to be signed into law by President Trump. Okay? And immigration lawyers like myself are not happy with this law. Okay? What it says, that the two big things that this law stands for, all right? First, it makes immigration, it makes certain non-citizens subject to mandatory detention. Let those two words sink in. Mandatory detention. All right? If somebody commits a crime in the United States, they get arrested, then they go to an arraignment, and then they are often given a hearing to discuss bail or a bond to pay a certain amount of dollars and then be released. All right? What this law is saying is, nope, no more bond. No more getting released. You're going to be stuck no matter what. All right? That's what this law stands for. It says certain undocumented immigrants in the United States are going to be subject to those two words, mandatory detention. Why? Based on what? Based on mere allegations of having committed certain offenses. Based on a mere arrest, no conviction required. Okay? Based on mere allegations that certain offenses were committed. And those offenses can include misdemeanors like theft or misdemeanor robbery or things of those natures, which might sound really bad, but if you're arrested for something based on no evidence, and then that case gets dismissed, you could still be subject to mandatory detention under this act. Okay? And so you want to be, anyway, it's, yeah. Anyway, that's what this is. That's what this is. That's one piece of it. The other piece of this, it gives states the ability to sue the federal government, right? If they are basically, like if they want to challenge saying that, for example, if a non-citizen is released, right? Or given a stay or something like that, and the state disagrees with that decision, it gives the state the right to sue under this and basically say that federal immigration authorities aren't following this law properly. Okay? And so, some states are going to be all over that, and other states will probably never do that. Right? But those are the two big key provisions of the Laken Riley Act. Now, let me clarify a few things because there's a lot of questions out there. And as I'm talking, if you have questions, submit your questions. All right. I see folks. Ken, I see you there. Allie, I see you there. Claudia, Gabby, maybe it's Gaboy. Gabby, no, it is Gabby. Yeah. Tanya, I see you here on TikTok. Princess Fiona, hello, I see you there. Everybody on YouTube, Facebook, LinkedIn, everybody that's tuning in right now, like hello and welcome. My name is Otis Landerholm, and I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream, and welcome. And thanks for being here. And we're talking about some of the craziness that has happened just in the first week of the Trump presidency. And now we're talking about this law that is about to be signed into law, and it's called the Laken Riley Act. And I've talked about what this law does, and now let me clarify some of the limits, all right? Okay, so this law does not change detention and the rules around detention, the laws around detention for non-citizens who have already been admitted to the U.S., okay? So if you're undocumented and you've never been quote-unquote admitted lawfully into the U.S., then you got to watch out. You're subject to Laken Riley. But otherwise, if you've already been admitted, so for example, if you're already a lawful permanent resident, if you're already a refugee, like you were admitted as a refugee, if you already came in as on a non-immigrant visa of some kind, right? Then you are not subject to this. Okay? Now, another thing, it does not change detention for non-citizens who are charged with being an arriving alien. All right? Or if you started out in expedited removal and that's the only issue, then you can remain eligible for being released on parole. Okay? It also doesn't change detention law for non-citizens with final orders of removal by immigration judges. All right? Those laws are difficult, but it doesn't change those laws that have been in place. All right? But it does expand, and what it really is doing is it's making it impossible for a lot of people to be eligible for bond. Okay? So people will not be eligible for bond. They're going to be subject to mandatory detention, even though they have the right to fight their case in immigration court. All right? So they're going to be in removal proceedings under Section 240 of the Immigration Nationality Act, regular removal proceedings, but they will be subject to mandatory detention. The words of the act say that they're subject to mandatory detention any non-citizen who is quote-unquote charged with, arrested for, convicted of, or admits having committed, or admits committing acts which constitute the essential elements of any of the following. And they include burglary, theft, larceny, shoplifting, assault on a law enforcement officer, or any crime that results, basically any violent crime, any crime that results in death or serious bodily injury to another person. Okay? And so that's the way it is. That's the way it is. All right? That's what I wanted to share today. Thank you for listening to this. I hope that's useful. I hope that's helpful information. If you know someone who is undocumented and who has an arrest or a criminal history, right, that they want to talk through, have them talk it through. All right? Let's have them do a consultation. Let's meet. Let's go over it. What can we do, right? And sometimes this requires working with an immigration attorney and a criminal defense attorney so that we can work together and maximize the quality of the result, okay? Which is hopefully, to fix your immigration status so that hopefully you can stay in the United States, right? That's what we're talking about. That's what we're going for. All right, so let me send me your questions. I'll do my best to answer them right here, right now. And let's do this. Let's see. So, Nikki, I see your question here. Do I have to carry my DACA card, or can I keep a printed one? Thank you, Ricky, for asking that question. You know, we're getting a lot of questions, even citizens, even folks on with current green cards, even folks with current cases that are pending. Even, you know, it's like, what documents should I carry? You know, if immigration were to stop me, what documents should I have? And this is there's not a one-size-fits-all answer, right? But for the citizens out there, like, imagine that you don't look like a U.S. citizen, but you are one, right? I mean, I'm sorry that we're living in a world where this matters, where how we look matters, right? But it's like, with everything Trump is doing, that's gonna be the reality. All right? Like, if you're stopped and somebody says, "Hey, where are you? You know, where are your papers?" and you say, "I'm a U.S. citizen," and the officer says, "Yeah, prove it." What do you do? You know? I mean, first of all, nobody should have to be in that situation, right? But just so that I'm clear, the way to prove that would be to have a copy of a U.S. passport or your U.S.-based birth certificate or something like that, right? That's the way to prove citizenship. If you've got a green card, have a copy of your green card or show the real thing, or what, you know, that's the way to prove that you're a green card holder. If you have a case pending, have your receipt notices, right? That's typically the way to do that, you know, have your receipt notices, right? If you have DACA, at the very least, have a copy of both sides of your work permit, right? That doesn't necessarily stop the challenge that we'll face out there, but it can help clarify the situation. I should do a whole episode on like what documents to have on you and when. Let's actually do that. My team, who's watching this right now, you know who you are. Let's create a episode about that. What documents do I carry on me and when, and what do I say if, right? And we can talk all those scenarios through. We'll do that. We'll do that as an episode. That's important. If anybody's out there that's interested in that episode, tell me, all right? Put that in the chat or something. And if anybody's out there and really is interested in that episode, take a moment, go to our channel in YouTube, and hit the subscribe button. All right? Hit the subscribe button, hit the notifications bell, and you'll be notified whenever, you know, the way to do that, if you go to youtube.com and you type in Landerholm Immigration, that's the name of my law firm, and then our channel will come up, right? And if you subscribe and hit that notifications bell, you'll be notified when we upload that video, okay? So we'll do that. We'll do that video. Ricky, thank you very much for asking that question. And yes, you could carry a copy of both sides of your DACA. It's better to have the original, but hey, at least you could say, hey, I'm currently lawfully in the United States pursuant to this work permit. And then hope that they don't ask further questions, really. All right, Kiki, love to tune in. Hey, Kiki, thank you so much, and thank you for being here. I appreciate you. Jack, I see you here. After submitting a medical case, they approved, let's see, after submitting medical case was approved, but status says the case was reopened. What does that mean? I don't know. Jack, that's a good question. I'm not super clear about it. So sometimes, though, they'll reopen the case and approve it. Like if the case was closed before, sometimes they'll reopen it and approve it and issue the green card. So maybe that's what it is. If that's your situation, you were like, if they were just waiting on the medical exam and then you submitted that and then they reopened it and got your case approved. So we'll see. We'll see. So all right, Emmanuel. Let's see. If I am a resident, could I sponsor my wife who's undocumented and came illegally? I've been watching other live sessions. Emmanuel, thank you so much for being here. Here's the way it works for spouses of permanent residents. All right. A permanent resident, yes, has the right to petition for spouses and unmarried children. Okay? Permanent residents, lawful permanent residents of the United States have the right to petition for two people, spouses and unmarried children. Okay? That's the way that works. The petition is the first step. Then the second step is, can your spouse or your unmarried child use that petition to adjust status? And that requires an analysis. Okay, that requires an analysis. Were they lawfully inspected and admitted or paroled into the United States? Are they protected by what's called 245I of the Immigration Nationality Act? Do they have some other way to be able to adjust here? Or do they have to process the case through a U.S. consulate overseas, right? And sometimes that's just that's the way it is. Other times, you might be able to switch that situation. Somebody might, for example, be able to adjust status as soon as the permanent resident becomes a citizen. Okay? And so, what I would say there, Emmanuel, is it'd be wise to have, for you and your wife to do a full consultation and figure out what's going to be the best process for your wife, all right? So if she came in unlawfully and if she is not protected by 245I, then you might need to file the petition first, then do a waiver, and then do a consular process. It's a long process, but that might be the way to do it for her. Okay? So anyway, that's the way that works. All right, Govintor, which bill won, please? Maybe what I was talking about today, our theme for today, is it's the bill called the Laken Riley Act. All right, that's the act that has been passed by both sides of Congress, and we expect it to be signed into law this week by President Trump. It is a nasty law for immigrants, and it requires that certain immigrants be subject to mandatory detention, which is like, awful, right? It's awful. It doesn't mean you can't win your case. It just means you might have to fight your case from inside detention for a certain amount of time, all right? Which is awful, okay? So I can share some of my own strategies about what we're going to do to counteract this law for our clients, etc., for the clients that are working with us. I can do that on a separate episode, right? I'm not going to do that right now. But there are strategies out there. There are things that lawyers can do ahead of time, right? So that we can maximize our clients' chances of winning, even if they were detained, right? Okay, like let's think that through. Let's build your case now, just in case that happens, right? So then, hey, we're ready. Even if that happens, we're ready, right? And we can take precautions as possible to prevent that from happening as well. But man, we want to be prepared, folks. Working with like smart immigration lawyers that are understanding what's happening, we can strategize and get ahead of the game, right? That's the way to do this. So, all right, Nadine, I see you here. What if the arrest happened years before you received your green card? Can you apply for citizenship? Okay, talk it through with your lawyer, but yes, I won a big citizenship case last Wednesday, all right, for a client who had serious criminal records from the past. He was technically, quote-unquote, deportable. I was afraid that client was going to be detained. We let the client know, hey, there's a risk that you could be detained at your citizenship interview, right? Client knew that. He understood, but he wanted to do it. He's like, I'm tired of this. Let's get this sorted out. We went in. We got his case approved. We won. The guy's going to be sworn in on the 29th, tomorrow, as a U.S. citizen. All right? And so it's like it's still possible to win cases. Anyway, so Nadine, the answer to your question is, if you receive your green card, if the arrest happened before that, can you still apply for citizenship? like yes, and talk it through with an immigration lawyer. All right, talk it through. Like the best advice is to talk to a lawyer so that you can get real legal advice. All right, not just something, because it depends on what that arrest was. It depends on making sure that your green card application was honest about it, making sure that your green card application was done correctly, so that there's no problem when you go to apply for citizenship. There's also a bunch of other requirements for citizenship you got to make sure that you've met with. All right? Got to pay your taxes, can't have long exits outside the U.S. of more than 6 months at any time, etc. I won't go through all of that right now. But anyway, you talk it through with a lawyer so that you can get very precise legal advice for you. All right, let's see. Polyheg621, I see your question here. Would this be applied retroactively? For instance, for an arrest from 2015, the person currently has DACA. That is a very key question, all right? And I have not seen, and I don't have the answer to it, and I don't know if that answer exists yet, all right? But that is a very key question. I have that question myself, and I'll be looking for how this act gets interpreted as to whether or not it applies going forward or retroactively, etc. Okay, so very good. Joel G, hello lawyer, we have C14, you mean a C14 work permit, all right, through a U visa. Are we in danger to get deportation? All right, here's the way to answer this. All right, here's the way to answer this. A C14 U visa, like pending U visa, does not give people protection from does not give people like certain protection from being subject to immigration enforcement. Okay? It's better than having nothing, but it is not like a valid, it's not like a green card. It's not like a visa approval yet. It doesn't put a person into lawful status yet, all right? It's better than having nothing. It's a lot better, actually, than having nothing. But it is not like if you otherwise have a deportation order, if you otherwise have a criminal record, if you otherwise have serious problems, you might be at risk even with that C14 work permit. And it's something you got to be aware of. All right, you got to be mindful of. Okay, Sanja Kumar Patel. If ICE catches me, do I still have a chance to go to court? Sanja Kumar Patel, thank you for asking that question. The answer is it depends. All right, the answer is it depends. It depends on whether or not you have a deportation order already against you. All right, it also depends on whether or not you're subject to what's called expedited removal. If you have an order that's already signed against you, then no. They can reinstate that old order. Like, for example, if you were ever caught at the border and actually given a deportation order, expedited removal order at the border, then you have a removal order against you. You can't see a judge again, okay? And what the executive order that was signed last week says is anybody that's been in the U.S. less than 2 years can be subject to expedited removal. And so if you're in that situation also, you got to be cautious, got to be mindful. Okay? All right. So, but otherwise, if you don't have a deportation order against you, if you're not subject to expedited removal, then yes, you have the right to fight your case in court. And Sanjay Kumar, that is like a key right. Okay? And so that's right. So Maria Lacerda, hello. Good to see you. Thank you. Hello. If a person has a case administratively closed and has a U visa pending, can you talk about that? Yeah, Maria, thank you for asking that question, all right? So if you have a U visa pending, all right, that's good. If you have a case that's administratively closed, that's good. You're not going to be subject to being deported. However, it's possible that immigration could try to recalendar your case and put you back in immigration court. Like if they wanted to deport a person in that situation, they would have to recalendar your case. Okay, so that's what you got to know. Yep. Miaja Su, I see you there. If does that say girlfriend was detained by ICE or GF detained by ICE? Can we call your office? Yes, if somebody's detained, like if a person is detained by ICE, yes, you can call our office. All right. We may or may not have the bandwidth to take that case in any given time because we have a limited team and we have a lot of clients, right? But yes, you can call our office. Everybody can call our office, all right? We give a free evaluation for everybody that contacts our office. The consult with the attorney is a paid consult, all right? And we request that that payment be done in advance to reserve the time because we are like slammed right now, folks. All right, but that's the way it is. But everybody can call our office and have a free evaluation. My intake team that does the evaluations, they are outstanding. All right, and they are here to help, and they are ready to take any call. If you've got a question, feel free to give us a call. Right. All right. So let's see. I see a bunch of other questions here too. I've got time. Yeah, I've got some time. I'm doing okay. I've got time. I'll take 5 more questions. All right, I'll take 5 more questions right now. So let's see. I'm going to back up a little bit. Let's see. Leaf Rain. I think that's how I say your name. I entered the U.S. in 2016. I got my EAD. I have an asylum case pending. Am I in danger? Okay, thank you for being here. Thank you for asking that question. That's a good question. All right, well, you're not in danger of expedited removal. You've been here for more than 2 years, so that's good. You've got your EAD. You've got an asylum case pending, so that's good. Most of the people that have an asylum case pending, they've got to hear your case, right? They can't deport a person without hearing their case unless they've got a deportation order already signed against them. And so are you in danger? I mean, no, you know. The danger is, what if your asylum case gets denied? You know, then, you know, so asylum is always a risky process because if you file and if you lose, then if the judge denies your case, they have to order your deportation. Now, you have the right to appeal that, right? And so, but yeah, I don't think you should be in any like immediate danger. Okay. So I hope that's useful. Hope that's helpful. Mike Johnson, let's see. I came in on a B1, B2 visa, so that's good. What was there a separate question there? I don't think I saw that one. Okay. Lori W, is this live? Yes, this is live. TikToker, do you speak Spanish? Yes, we'll be doing this episode in Spanish in just a minute. All right, I see a question here. If a deportation order is already issued, what are my options? Talk to a lawyer, see if there's a way to reopen that deportation case. All right? A motion to reopen is the way to get rid of, right, a deportation order. Right? Now we got to see, was that order executed? Were you actually deported in the past? Because that causes, that makes it almost impossible to reopen the case, and then we got to look for other options. But that's the way to do it. All right? And really, in a situation like that, we start by running all FOIAs, which takes time. And so I would say, like, hey, let's get started. Let's run all the FOIAs first. Then let's look at a motion to reopen. Then let's look at what we would do if the case is reopened in immigration court. All right, that's the way to do it. All right, let's see. Salsa Queen, cool name. All right, if I have an I-765 and an I-131 and an I-485 pending, am I protected? Yeah, for the most part, you know. For the most part, that's good. You've got your case going. You're filing for your green card. Don't commit any new crimes that would subject you to the Laken Riley Act and mandatory detention. But even if you were subject to that, you could probably fight your green card in front of an immigration judge. Worst case scenario, right? All right. Hopefully that's useful information. What type of protection does DACA give us? Lauren, I see you here. What type of protection does DACA give us? I have my copy of my approval letter with me and my EAD. Yeah, that's a great question. You know, it gives you some type of protection, right? You're not technically like in the U.S. in violation of immigration laws at the moment, right? You have DACA status, so that's good. All right, and now the question becomes, what are they going to do about DACA? Many people saw the order from the Fifth Circuit just last week, I think it was, denying DACA. So that's going to go back up to the Supreme Court. Anyway, it's a frustrating situation for a lot of people. And Lauren, if there's a way for us to change, you know, out of DACA status, like let's talk that through, right? Let's see, Siva's girl, I hope I'm saying that right. How can we find out if someone is on that deportation order? Okay, the way to find out if somebody has a deportation order or if somebody is subject to a deportation order is by running what we call FOIAs. All right, for anybody that's not familiar with that term, FOIA, FOIA, stands for the Freedom of Information Act. And that is a law, right? And it grants all people, you don't have to be a citizen for this, all people, all right? Documented, undocumented, doesn't matter. Every person has the right to request and receive and review the records, all right? And that becomes a very important part of due process. It becomes a very important part of an immigration case because we want to request and receive and review all of the immigration records that have happened in the past so that we can know and be prepared for how to maximize your chances of success in the future. Okay? Immigration records are key. Okay, Mike Johnson, I see you. I came in on a B1, B2. What if I have a T visa pending and put the asylum pending? What if I have a T pending, put the asylum pending? I'm not clear about what that's saying there, Mike. Thank you for being here and thank you for asking that. If you have a T visa pending, then good. If you have an asylum case pending, then good. And ultimately, you're going to see which one of those gets approved. If asylum gets approved, then really you don't need the T visa anymore. If the T visa gets approved, then I would hold on to the T visa, use it to adjust status. Once you adjust status, then terminate the asylum. You know, that way they can work as plan A and plan B, right? And that's totally fine. It's okay, everybody, to have 2 or more immigration processes going at the same time. It's perfectly okay. Sometimes that's the best strategy, right? All right, folks, that's all I got for today. Thank you all so much for being here. I really appreciate everybody who is here. You know, my empowerment tip, it's like all the stuff that we're talking about. Trump is back. He's making changes. I want everybody to be ready, all right? Be prepared. But I also want people to be calm. You know, how do we be calm in the midst of the storm? You know, how do we be centered in who we are, right? Like, if immigration comes and knocks on the door or whatever, how do we stay calm and not panic? How do we, it's like the best advice is to be true to yourself no matter what. All right? Let's be true to ourselves no matter what, right? Like I'm going to choose how I react in any given situation. If I want peace, I'm going to be peaceful no matter what. All right? If I want joy, I'm going to be joyful no matter what. Right? You can't take me away from me, right? You can't take my thoughts away from me. You can't take my mood away from me. You can't change me. I am me. I really want people to still be true to themselves. Be true to yourself. Right? We will get through this. And I want that for you. I want that for everybody, you know. Like, this is the Empowered Immigrant Live, folks. I want to empower people. Be yourself. All right? It's like we don't have to live in fear. What are we, if we're true to ourselves, then nobody can take that away from us. Right? Food for thought. Anyway, another thing I wanted to share, so this is for current clients of my firm only, right? This Thursday, anybody that's a current client of my law firm, this Thursday at 3 p.m., I'm going to go deep in how to defend our rights during Trump's second term. All right? And we're going to be talking about it 3 p.m. Thursday afternoon in a conversation that's just for my firm's clients. I can share some of it I've shared live also, but I really want to share the screen and welcome clients to interact with me and share what's going on. So we're going to talk that topic through this Thursday, the 30th of January at 3 p.m. Okay, that's all I got, everybody. Thank you all so much for being here. Everybody that's tuning in right now, whether you're on YouTube, Facebook, LinkedIn, Instagram, TikTok, thank you. Thank you for being here. All right, we got this. We can survive this. We can overcome this. All right? But let's stick together. Let's stay informed. Let's keep talking it through. Let's keep educating ourselves. All right? Let's keep fighting these fights. There's going to be cases that we got to fight. That's the way it is. Okay? All right. Thanks a lot, everybody. Make it a great rest of your day. All right. Take care. Bye-bye.